The pandemic has brought to the fore a whole host of legal challenges when it comes to workers' rights. The most recent capturing headlines this week, the convoy of truckers and their supporters protesting COVID-19 mandates, specifically one that would require cross-border truckers to be double vaxxed in order to avoid quarantine. But for those not in compliance with that federal mandate, what legal rights do they have? Employment lawyer Lior Samfiru is here to weigh in on this and other employment news. Good morning, Lior. Thanks for joining us.
Good morning, Candace.
So let's get right to it. Can an unvaccinated trucker lose their job if it affects their ability to transport across the border because of the mandate?
So with this mandate that has been created, the effect of that is that a trucker now is not able to do their job. They're not able to properly cross the border, deliver their load and come back. And because of that, an employer is faced with a dilemma. I have a worker that can't do their job. So what happens in that situation, given the fact that it's not the employer's fault, it's not the employer making a decision to not have the employee work, that employer is able to terminate the trucker without any compensation for not being able to do the job. We often refer to this also as frustration of contract. So for these truckers, it is bad news because in your normal situations, you will get compensated. Right now, in this particular situation, you can lose your job, no compensation. Obviously, that's not very good.
You know, in other industries, there's, I wouldn't say a requirement, but an expectation that accommodation is made in some cases. Are trucking companies not required to do that as well, perhaps by way of another route, maybe a domestic route if they can't cross the border? What is considered reasonable accommodation in this sector?
So a trucking company or an employer generally is not required to change the job to accommodate an employee's vaccination status. Now, where a trucker doesn't often drive cross-border, they mostly drive within the border, then an employer is expected to work with them to make it happen so that they don't have to cross the border anymore. But where it's a real and fundamental term of employment that you cross the border, you're the guy that crosses the border. The employer in this case is not required to change that, to make it different, to give them a different route. They can simply say, unfortunately, you can't do the job. And until that happens or until that changes, you don't work here. So that accommodation requirement is going to be quite limited here.
Gotcha. So let's switch gears now to a $150 million, class action suit that's been launched against Pizza Hut by its delivery drivers who argue they've been misclassified as independent contractors when they're actually employees. And as a result, just to summarize, they're entitled to basic rights, including minimum wage, vacation, and overtime pay. What can you tell us about that?
So this is a very common issue when it comes to employment law, this idea that individuals are misclassified as contractors when they're really employees. If you think about it, if all you had to do is sign a piece of paper saying you're a contractor, then anyone can be a contractor. The real issue is, are you in business for yourself? Or are you really working for someone else? Does a company control what you do, or do you have full say over your job? If you've been misclassified, well, there's consequences to that. And I think the employees here or these individuals at Pizza Hut are saying, well, wait a second, you're calling us contractors, but we really look like employees. As you know the saying, if it looks like a duck and quacks like a duck, it's a duck. Same thing happens to employment.
Okay, so more generally speaking then, what does an employee make? How does someone know if they're an independent contractor or an employee? Because some of those requirements there could be arguable.
Absolutely. And there's not one factor, there's a number of factors. For example, do you have control over your hours, or does someone else dictate your hours? Do you pay your expenses, or does someone else pay your expenses? Do you choose how to do the work, or does someone else choose how you do the work? The best example I'll give you is this. If you have a leak at home and you call a plumber to fix your leak, that plumber doesn't work for you. He or she is an independent contractor. So the question you ask yourself is, am I like the plumber, i.e. I'm an independent contractor, or am I something else, in which case I'm likely an employee?
Okay, great example. And back to the class action quickly, $150 million. What happens if it is determined these drivers are employees? What will that mean?
Well, if they're in fact employees and this whole time they've been misclassified, well, they haven't been paid overtime, they haven't been paid vacation pay, they haven't been paid minimum wage, etc. So that liability to them going back a few years could be quite a few $1 million. So Pizza Hut has a tremendous liability here if these guys are employees, and it could potentially get worse because CRA may look at this and say, well, wait a second. You haven't been withholding taxes. You haven't been paying into the EI system for these individuals. So now you owe that money plus potentially some fines.
I see. Well, thanks so much as always. That is Lior Samfiru, employment lawyer, always educational and always helpful. Thanks again. Have a good day.
Thank you.